First of all, I would like to pay high respect to Honorable Excellency, ladies and gentlemen. My name is Chay Sophal. I'm a student at PUC. My major is International Relations, or we call IO. Today is a good opportunity that I want to share everyone about some concept of international law. Okay, now we start about the international law. You know, when we see, we heard the word international law. What is international law? International laws, it means the law that was created between two or more countries to agree or to make agreement depend on the problem that happen between border or any field of the country along together. Thank you. Let's start about international law. International law was used by Jeremy Bentham in 1780 to promote the peace and security, or we can say to promote moral and legislation in the country, one country to another country. Like, also international law also depend on the customary or norm, principle or rule in which country before they make a law to promote all of this. Okay, now we will move to the originate of the international law. Originate of international law, it comes from the since 16th century that have a conflict between two countries, Catholic and Protestant, that had conflict on the religions. During that time, we have they show the problem of have a treaty in a Westphalia city to end this religious war. Okay, now we move to chapter 3. We talk about the source of international law. The source of international law we can define as four ways. The first, international convention. International convention, it means the more country, 2 or 3 or more than 2 or 3 countries make a conference or make the meeting or the big meeting to make international law. We can say after international law convention. The second is the international custom. It means some custom is good for the world or for the global. So we define the custom, or we take the part of the custom out of the international law also. The next we take from the general principle of law. It means the general with some concept of the world, or some concept that can make the world as the peace, or the world as the economic process or security. Okay, we take the concept to the international law also. The last one we talk about the judicial decision. It means that some laws in the country, like in one country, for example, in one country have already a domestic law, but that law is so nice, that law can apply to the world. So the whole or the many countries make a decision to catch or to take that laws out of the international law also. This is the element of the source of international law. The four that refers on international law incorporate into domestic law. It means that it's not all international law, all chapters or all articles that all countries can accept it or adopt it. Some law or some international law can affect or cannot adapt in the one country because we have conflict. We can say conflict law between domestic law and international law. So we compare between both international law and domestic law. Sometimes can accept it, and some article cannot accept it because it affect with the domestic laws in that country. So when before they make the international law or article in the international law, we define or we observe in the own domestic law before we accept or adopt the international law in own countries. To find that we talk about state. What is state? You know, when we define state, we have 4 elements run together. First, we talk about a permanent population. Permanent population, it means the people or citizens that live in the country for long term. Like, for example, in Cambodia, we have more than 14 million population that live for long term from in the past and until in the future, and mean many years ago. This is, we can say, permanent population. The second one is territory. Territory, it means we have land border. Like we have border with Thailand and Cambodia. We have Laos, we have Vietnam, and also we have the border with the sea. This is the territory. For the third one is sovereignty. Sovereignty, it means we have capacity to enter to relation with other state. It means we make a relationship in the economy, to make a treaty, to promote peace and security, or to modify the country into, we can say, to promote any product or to export, import the product with other country by own sovereignty. Okay, in the last one, you know, when you have 3 elements already, like population, territory, sovereignty. But if you don't have a government, you still cannot define for the state, because government is so very important. Government is like a machine of the country, or we can say like the head of the countries. For example, if you have a car or motor, is a car of motor doesn't have the machine, you know, it is cannot run, it cannot process. So the government is so the very important element in the state. So in the state we have 4 elements: population, territory, sovereignty, and governments. Now we move to the chapter 6 that we talk about international organization. International organization is an organization that was created by the agreement between state and state that have the one specific purpose. For example, like committees of Red Cross, it means to the monitoring the Geneva Convention in the laws of war. You know, for another example, like ILO, it means International Labor Organization, that specific on the labor rights or labor condition in over the world. So this is the international organization. You know, to sum up all this chapter 6, it means before we have international organization, where we observe the one country that have a good condition of living standard, like labor or human right, or this or not yet. If that country has many problems related to the work condition or human right, we can say the many country or the modern society, or we can say the powerful country like United States or any international organization will observe or exist into that country to promote the international organization, or to make that country to ask that country to join international organization that was created already. Chapter 7 we talk about jurisdiction. Jurisdiction, it means the power the state have. It means the state also has the own power to to do or to exercise any law or to create the domestic law for own country. It means that for the country that have domestic law already, they can have power. They have the power to decide or to judge in the own country that has any problem, to show own country even if have international law. But when the country that accept or adopt the international law, also when they create a new domestic law or we have an old domestic law, need also observe or follow, or it means we can say before they do, they need check the international law also. The worry about affect the human rights. Now we move to the chapter 8 that we talk about the sovereignty and immunity. Sovereign immunity, it means the power, the right that we can protect ourselves in the another countries, like the ambassador that work at other country, they have immunity to protect themselves by the arrest by the police in that country, or the judge, the court that judge that action even if they commit any crime. They have a right to protect themselves, all countries we have equal right, we have equal right, or we have equal power. You cannot exercise over your country to another country, because we have own power to do anything, depend on the jurisdiction. But for the immunity, also have a right that protects, any foreigner in your go to your country that they visiting or they do the investment work for long term in your country. They have a sovereignty to protect, because sometimes they commit the crime, but it's not mean that you judge or your court can decision only your domestic law. You need to confirm to their country to decide or to judge them or to return them to own country back to their court to the judge their action or their crime. Chapter 9, we talk about treaty. What is treaty? Treaties is the agreement between state and state that we have the written form to modify either the form or form, and it governed by the international law. So they need a treaty. For the treaty, we have two kinds of treaty. We can say like the liberal and municipal treaty that they use in four kinds of treaty. The first is we can say unilateral treaty. Unilateral treaty is the one made between a limited number of states with the particular interest in the subject matter. The second is constituent treaty is one that establish and manage the international organization. And the third one is universal treaty. It is one treaty that that is intended to apply to all states. And the last one, the regional treaty, is the self-explanatory treaty. Okay, this is the treaty that the kind of treaty that covered by international law. 14, that we talk about the human rights law become a matter of international law. Human rights, it is, we can say, for the world, we take care about the human right. Before, we don't care because we take care only the peace and security between state and state. We worry about the war between state and state. But for the modern society, it's not the peace and security focus on the war between state and state. It also the abuse this human right in the country by the state. It means some state, more state that create the human right, but the most of people also violated by the state. Why also that? Because some the government is manage or protect their power by abuse the right of people. They violate the right. They strict the public speaking. They abuse the public expression. This is the action that the government used to abuse the right of people. So when the one country that abuse the right of people, it affect to the world because we want to peace, we want to have peace. It means we avoid the war. If we avoid the war because we want the people live in standard. It means people have food to eat, people have the house to live. People have any right to express their ideas. But when the people, also the country doesn't have the war, but in the country, the citizen abuse the right, people don't have rights, don't have power. This is, we can say, affect to the peace and security in the world. Talk in the chapter 17 that focus on state responsibility. For the state have an obligation to protect their own, their own territory, their own population, their own sovereignty. But the state also have obligation to follow, to accept the international law or to protect the international process. Like, for example, in the environment, all states have obligation to, to protect or to take care with the environment. It's not only one state, or for example, only a United States, the United Kingdoms, or another country, but all country in the world, all state in the world has obligation, obligation to protect it to the all people in the world. This is beside any violation or any war. But for the war, it is also even if you have your own territory, you have a sovereignty government, you have your own state, but it's not mean that your state is special or your state is the most important, that you don't care with other country, you do anything only for your country. I think it's again the international convention or international law. International law, international obligation. It means all states have a responsibility. Have a responsibility altogether in violation human right or any protection and any field that can be affect to people. Okay. The 18 that we talk about diplomatic measure of settlement. Any country, before we have an international law, we also have conflict between country and country. So for the solve the dispute or settle the dispute, we have three kind. First, the first is negotiation. Negotiation, it means we involve or we negotiate between two parties and discuss or show about their interest together to reach the you know to reach the agreement or to reach the solution. But if the both party still cannot solve the problem, you know, we move to the mediation informal measure. It means we have the third party, you know, involved in that case or that issue, but the third party, you know, is just for the listening, or we can say the evidence in that case, and try to convince them to show that you know to agree to reach the agreement. But the both party they still have one agreement on that case. They still disagree together, so they move to the last, you know, the last solution or that diplomatic measure, you know, the conciliation, you know. And conciliation also helps third party, but the third party in this case, in this way, has much more power than mediation. Conciliation, third party have right to check and do and make the proposal claim to the ICJ. Two party, you know, need to accept that claim that third party prepare for them to the ICJ to show. Okay, this is the, you know, the diplomatic measure of the settlement that we need to show diffuse during they have a conflict between state and state. Okay, I have only this for the chapter the chapter 18. Okay. Okay, now we move to the chapter 19. They will talk about the choose as a balloon. It means pre-war, or we can say prepare for war, or we can say declare before we declare the war. Before we declare the war, unless we have four reason. The first is, you know, having a just cause. Having a just cause, it means you have a good reason. You have a real reason that you need a war to protect your country. The second one is you have, having right intention. Having right intention means that when you see the country, even if it's not that war involved or specific on your country, but when some country have a conflict or the war near your country, closely with your country, also you declare the war, because one day it can be affect with your country. It can be affect with your country. So you need clear the war for protect your country. The third one is proper authority. Proper authority, it means you declare the war because territory, because some group is like some of territory, some territory that will affect, territories they affect or prepare to make your country unstable. So you declare the war with them. This is the reason that you should do. And the last reason, it means the last choice of you, that if you think the situation can make your citizen or can make your country not safe or in the security, so you can declare the war also. Okay, this is the chapter 9 at the just and Balam or pre-war. Last chapter, in chapter 20, that we talk about just in Belu, or we can say during the war, before you declare the war, and the war after war declare, it means during the war. During the war, how should or what should you do in during the war? It means during the war, you should vow this armed force. It means some military that they have we don't have ability to fight with you, to fight with your military, so you cannot kill them during that time. And the second one is sick armed force. Sick armed force, it means the military or a civilian that got sick. That they got sick. This is the any problem that you cannot do during the war. Also in the civilian, also you cannot kill the civilian. You do the war. You commit the war, but now the international law not allow you to kill the civilian or the people that is not the army, or it's not it's not the military. This is the purpose of the chapter 20 that just in the below and mean during the war. Okay, and finally, thank you for your paying attention in my sharing. Okay, bye bye.